Hey y'all, Rob here with ATX Legal, and today I'm here with the next part of the 2023 Travis County DWI Guide. And in this video, we're just going to be talking about the process and how long it's going to take. One of the most common questions I get from people is how long is the whole process going to be? And for many people, it's their first brush with the criminal justice system, so they just have no idea. Maybe you've heard that justice is slow. Well, that's accurate. So with a DWI, you're looking at an average DWI is going to take 9 to 12 months, and there's going to be some exceptions both on the short side and the long side of that. But you can definitely assume that 9 to 12 months is going to be an average for a typical DWI. Now, on the shorter end of that, if you do get accepted into DWI diversion court, and I do have another video that discusses that, it'll be more in the range of 4 months or so. If you decide to take your case to trial, you're looking at more in the 12 to 18 month range, or even longer in some cases. And then there are some other factors that can delay your case as well, and I'll talk about that right now. One of the most common factors that's going to delay your case is going to be lack of discovery, and specifically the blood results. The breathalyzer results will come right away, but the blood results have to go to the lab. It can take 4 to 6 months. If they have to test it for drugs as well as alcohol, it actually has to go to a separate lab. That can take even longer. The prosecutor is going to be unwilling to really do any plea negotiations before that lab comes in, because it's going to really affect what kind of offer they're going to give. So until we get that lab in, it is a bit of a waiting game, and it's just a matter of a few months until we can really get started with your case. Now let's talk about court dates, and this really has changed since COVID, especially in Travis County. It used to be that pretty quickly after the arrest, within a few months, you would be needing to come to court basically once a month. There would have been some exceptions. That's kind of been flipped on its head now. You will have to go to court before you hire an attorney, and that's just to get your attorney sorted. But once you have an attorney, you're probably not going to be going to court for months and months. Your attorney's either going to be able to handle those settings for you, or those settings will be pushed out by the court and while you're waiting on those labs. There are some exceptions to this, so of course always listen to your attorney. And there is a link in the DWI guide where you can click on the Travis County Docket Search, and if it says appear by your name, you will need to appear. And always listen to court administration, although they do sometimes cause confusion. I've had clients that get the automated text message saying you need to come to court, and they'll call me in a panic when actually they don't need to appear. So listen to your attorney first. If you can't get a hold of your attorney, go ahead and follow the court administration if you get those text messages or a call from court administration. But in general, for DWIs, I've had clients that never come to court until they do a plea, or if we get their case dismissed, they never come to court at all. So things have really changed. It's gone away from that once every month model that it used to be before COVID, and now you might be coming to court very rarely, if at all. Of course, this is all subject to change. This is how it works right now in 2023. Could be different in your situation. So you might be thinking to yourself, while we're waiting on this case to be going through the courts, is there anything I can do to help myself? And the answer is definitely yes. So when you are given bond, usually it's one of your bond conditions that you go take care of these DWI classes. It's an assessment. It's usually a 12-hour class for Class B misdemeanors. It can be a 30-hour class for A's and felonies, but there's a class that you will be assigned to do. Like I said, it's one of your bond conditions, but people overlook it all the time. And if you don't do it, nobody really hounds you to do it. But if you complete these classes, it can actually help with your plea negotiations. So I'd recommend doing the DWI classes as soon as possible. There's also a Mothers Against Drunk Driving MAD Victim Impact Panel that's about a 2.5-hour class. If you can complete these classes early, it's going to help your case. Another thing you can do is, if you do have an ignition interlock device, be sure to keep it clean. If you have a clean record on your IID, it's actually going to help you with plea negotiations. It's not a fun thing to have in your car, but it can definitely help your case. And remember, any amount of alcohol is a violation for the IID. It doesn't just have to be over 0.08. One way a lot of people get into trouble is if they go out drinking the night before, they go out to their car in the morning, they blow into their car, that's a violation. That can actually restart the timeline on all the credit you're getting for that IID. So when you do eventually do a plea that involves an IID, you're going to have to do months of extra ignition interlock in your car because you had that one violation. Don't do that. Be very careful about when you blow into the IID that you're not getting a violation. And once we have all the discovery, all the blood alcohol tests and everything together, plea negotiations do start, and those can take a few months as well. And why do those take a long time? Well, it's actually usually in your best interest for it to take a little bit longer. And think of it, if you're negotiating for anything, you don't want to take that first offer. The attorneys who are taking that first quick offer and getting it off their plate, they're not getting as good a deal as the attorney that's willing to wait a little longer and push those negotiations further. And also just the passage of time will help the case. Think about it this way. I'm trying to paint the picture to the prosecutor that this was a one-time mistake. This is not a continuing issue that's going to happen over and over again. And the passage of time only supports that. Now, the things that can hurt it, if you do get a new charge, if you have a bunch of ignition interlock violations, that can go against that narrative. But in general, the passage of time is actually helpful to the defendant's case. Now, I do have clients for whom a speedy outcome is especially important. Maybe they have other things going on at work and they just need to have it resolved, or for whatever reason, it can be anything. I do talk to my clients, and if they do ask for a speedy outcome, I do work to get the quickest and best outcome I can. Sometimes that results in an outcome that's not as ideal as if you had taken the time and really worked the plea negotiations as best as you can. None of this has been legal advice, but if you would like legal advice on your specific case, you can visit us at atx.legal. I also have multiple parts in this DWI guide. You can click on the YouTube channel or click on the link below for a PDF version of the guide.